Hello all, hope you all are fine. In this video, we will talk about FIR against the doctors under section 304 IPC and other relevant aspects related to it. So let's get started. It has been observed that FIRs are routinely filed against the doctor under section 304 IPC, 304A Indian Penal Code or other sections of IPC or relevant acts. Here against the doctor means a doctor or a RMP who is competent to treat the patient or who is legally authorized to treat the patient. I am not talking here about quack or a doctor who is not legally competent to treat the person or a patient. Why these FIRs are filed? For causing death of the patient during treatment. In this video, we'll touch upon the following issues. Number 1. Whether filing FIR against the doctor under section 304 IPC. I am not talking here about 304A IPC. I am just talking here about under section 304 IPC is legally tenable or not. Second point, does filing false charges of offense by police constitute an offense? And lastly, what are the views of the Supreme Court about it? To clear the picture, please find here with one Supreme Court judgment. In this case, allegation was on July 4th, a patient with history of body pain was brought to the clinic. Doctor administered 3 injections to the patient. Within half an hour, the patient died. Thereafter, the son of the patient, hereinafter referred to as a complainant, approached the police to lodge a report against the doctor. Interesting part is, however, the police refused to register any case. Therefore, the complainant filed a complaint in the Judicial Magistrate Court on January 3, 2002 with a prayer to register FIR against the doctor under section 304 IPC. Magistrate directed the police for investigation. Thereafter, on Magistrate Court order, police made an inquiry and submitted the report to the magistrate, stating therein that no offense had been committed by the doctor. The patient had suffered heart attack. On police report, the complainant, that is son, filed protest petition to the magistrate court and alleged that the final report submitted by the police was biased, factually incorrect, and had been prepared only with a view to favor the doctor. Magistrate court accepted the protest petition and issued the process for commission of offense against the doctor punishable under section 304 IPC, and other sections were added to it. But we are just dealing here with section 304. Thereafter, the doctor challenged the said order of magistrate court before High Court. However, High Court affirmed the magistrate court order and directed the police for investigation under 304 IPC. Therefore, doctor approached the Supreme Court against the High Court order. What Supreme observed in this case? Supreme Court observed, before section 304 IPC can be invoked, the following ingredients must be satisfied. Number 1, the death of the person must have been caused, that is 1. Second, such death must have been caused by the act of the accused by causing bodily injury. Number 3, there must be an intention on the part of the accused. That is the first most important parameter is intention. For what? To cause the death. And second, intention to cause such bodily injury which is likely to cause death. This is the part 1 of section 304. And fourth parameter was, or there must be knowledge on the part of the accused, that is in our case doctor, that the act is likely to cause death without any intention having to cause death, will cause such bodily injury as is likely to cause death. Supreme Court further, it is of the utmost importance that those who may be entrusted with judicial powers should clearly understand that no conviction ought to take place unless there is evidence to conclude that such intention or knowledge have really existed. Supreme Court further observed, even if the averments made in the complaint are accepted in their entirety, the act in question of giving injections to the deceased patient would not fall within the mischief of section 304 IPC. In our opinion, therefore, no process could have been issued against the doctor for commission of an offence punishable under section 304 IPC. In spite of Supreme Court's such observations, FIRs are routinely filed by police or charges are framed by trial courts under section 304 IPC against the doctor even when there is no evidence to point out the existence of intention and or knowledge required under section 304 IPC. Therefore, unfortunately, doctor has to approach multiple courts to quash the FIR or charge sheet. Therefore, expectations from the police officials not to file FIR against the doctor under section 304 IPC if prima facie no evidence to fulfill the major ingredients of the said section, that is intention as well as knowledge. I am here referring another case from Gujarat High Court. In this case, Gujarat High Court observed that the framing of a charge by the trial court is not an empty formality. That means the trial court cannot frame the charge mechanically. The court at the stage of framing of charge, that is trial court, has to apply its mind and see to it that no prejudice is caused to the accused on account of framing of improper charge. The court further observed that the investigating agency also owes a responsibility to see that the appropriate sections are applied having regard to the nature of the accusation and other materials on record. Does filing of false charge by police officer comes under any offence? I am sharing here one Supreme Court's judgment delivered in 2014. This is an important judgment, I must say. Supreme Court observed that filing false charge of offence by police may constitute an offence under section 211 IPC. However, Supreme Court further clarified that the procedure laid down under section 195 CRPC and 340 CRPC has to be followed. I am not going to the details of this CRPC sections. Just have a look what 211 IPC says. Whoever with intent to cause injury to any person institutes or causes to be instituted any criminal proceeding against that person or falsely charges any person with having committed an offence knowing that there is no just or lawful ground for such proceeding or charge against that person shall be punished with imprisonment up to 2 years. It can extend up to 7 years too. In subsequent videos, we'll cover other various sections, other various case laws regarding medical negligence and various offences registered against the doctor for the same. Thank you so much.